Leo Maxwell was not a lawyer, but a title abstractor and real estate paralegal with a singular forensic expertise, the uncompromising history of property ownership. He could trace the lineage of a patch of dirt back 2 centuries, discerning the faint, often forgotten legal footnotes that dictated the true boundaries and burdens of land. His home in the exclusive, tree-lined community of Silverwood Estates sat on a half-acre lot that was, by all accounts, perfect except for the massive, gaudy cluster of community mailboxes the HOA had installed directly on the corner of his front lawn. For years, Leo had tolerated the mailboxes, which generated daily traffic, noise, and unsightly footpaths across his grass. When he approached the HOA, led by the imperious president Evelyn Shaw, about moving the structure 15 feet back onto the common area, he was met with casual arrogance. "Mr. Maxwell," Shaw declared during a terse email exchange, "that spot has been designated for community mailboxes for over 30 years. It is covered by a recorded easement. It is a long-standing, necessary utility location, and the board has no intention of incurring thousands of dollars in relocation costs for your landscaping preferences." The HOA relied on the perceived power of precedent and history, believing their long use guaranteed their right. Leo, however, didn't deal in precedent or perception. He dealt in the cold, hard, recorded truth. He immediately retrieved his professional tools, bypassing the cursory title search performed at the time of his home purchase. He initiated a deep dive into the root of title for Silverwood Estates, meticulously tracing the property chain of command back to the original developer's plat maps from the late 1980s. This was a process only a specialist of his caliber could execute efficiently, involving weeks of poring over microfiches, old survey records, and dusty county deed books. Following every conveyance and recorded burden, his goal was simple: locate the specific legal instrument, the easement by grant, that purportedly allowed the 3OA to utilize that corner of his property. He finally found it, a faded, water-stained document attached to a 1995 deed amendment. The HOA was right, an easement had been granted. But what Evelyn Shaw and the entire board had failed to do was read the fine print, the critical, time-limiting clause buried in paragraph 4B. The easement for community utility and postal access was explicitly granted for a specific, limited duration of 25 years, commencing January 1, 1996, and requiring formal, recorded renewal by both the property owner and the HOA board of directors before the expiration date. A quick calculation sent a chill of professional triumph down Leo's spine. The easement had legally and irrevocably expired on January 1, 2021, a full 4 years ago. The HOA had simply continued to use the land, relying on the memory of the easement and never bothering to check the underlying legal documentation. The recorded easements they claimed to rely upon had been legally void for years, meaning their continued presence on his property was, unequivocally, an act of continuing trespass. Leo did not inform the HOA of his discovery. To do so would have given them time to negotiate or attempt a frantic, retroactive renewal that might have muddied the legal waters. Instead, he meticulously built his case. He secured a certified copy of the expired easement and a recent title abstract proving its lapse. He then quantified the cost of the trespass. Using local commercial property rates for small utility parcel leases in the area, he calculated a fair market rental value for the 50 square feet the mailbox cluster occupied. Based on the 10 years of illegal use since expiration, 6 prior where they benefited from the flawed, unrenewed contract, he conservatively calculated the back rent owed to him at $12,000. He also obtained bids for the professional removal and relocation of the multi-unit mailbox structure, estimated at $8,500. Leo bypassed the HOA's internal processes entirely. He drafted and filed a concise, devastating complaint for trespass and ejectment and quiet title in the state superior court. The action was brutally simple. It demanded the immediate physical removal of the HOA's property from his lot ejectment, payment of fair market rent for the decade of illegal use damages, and a court order officially clearing his title of any claims by the HOA quiet title. The filing included his irrefutable evidence, the expired 1995 deed amendment, certified by the county recorder. The HOA, through its general counsel, attempted to fight it, filing a motion arguing easement by prescription or adverse possession due to their long, uninterrupted use. Leo's reply brief demolished these claims, pointing out that prescriptive rights cannot begin until the underlying, valid easement expires, and, since the expiration was only 4 years prior, they had failed to meet the state's minimum 10 or 20-year statutory period for adverse possession. Furthermore, their own legal reliance on the expired easement explicitly negated the required element of hostile use necessary for adverse possession, as they had always believed their use was permissive, not hostile. The court, recognizing the legal clarity of the documents, did not allow the case to drag on. The presiding judge, presented with the certified, time-limited easement, ruled swiftly and completely in Leo's favor. The judgment against the Silverwood Estates HOA was catastrophic. Immediate ejectment order. The HOA was ordered to cease all use of Leo Maxwell's property and immediately remove the entire mailbox cluster at their own expense within 30 days. Back rent and damages. The HOA was ordered to pay Leo Maxwell $12,000 in damages, representing fair market rent for the decade of illegal trespass and use. Attorney's fees. The court, citing the HOA's willful ignorance of documented title law and its attempt to waste the court's time with frivolous defenses, ordered the HOA to cover all of Leo Maxwell's legal fees, which had grown to nearly $15,000. The total financial judge made a removal, costs, back rent, and legal fees immediately hit the HOA's reserves for nearly $35,500. The financial shockwave was immediate and devastating. Evelyn Shaw, the president who had haughtily dismissed Leo's initial simple request, was forced to issue a humiliating emergency special assessment on every resident to cover the massive, unexpected, court-mandated expense. The HOA's failure to read a single clause in an old deed had cost the community tens of thousands of dollars, forced a chaotic, immediate relocation of a vital utility, and revealed the deep incompetence of the board. The heavy monolithic mailbox cluster was eventually jackhammered out of the corner of Leo's lawn and relocated to the common area. Leo used the $12,000 back rent and the $15,000 in covered legal fees to pay for a stunning, custom-designed hedge and wrought iron fence around his newly reclaimed property corner. He had used the obscure, immutable law of title abstraction to make the HOA pay him handsomely to clean up their own decade of legal negligence, and the entire community learned, at an extremely high cost, that the most harmless-looking piece of paper can carry the power of financial demolition.